Oh yay, oh yay, oh yay. The Honorable Supreme Court of Arkansas is now in session. All persons having business before this honorable court draw near, give attention, and ye shall be heard. May God save these United States, the state of Arkansas, and this honorable court.
Good morning, Chief
yay,
Justice.
Oh yay, oh yay. The Honorable.
Chief Justice Kemp has recused from the case that we will hear oral argument on today. Therefore, I will be presiding as the Chief Justice for today. Will the clerk please read the submissions?
The oral argument for this morning is an original action and certified question from the United States District Court for the Western District of Arkansas. The case number is CV-20-492, Samantha Edwards and others versus Eric James Cornell Thomas and others. In addition to our oral argument, also being submitted to the court for decision this morning are 10 other appeals and 14 other various motions and petitions. The court syllabus and details of all the submissions and decisions today are reported on the court's website.
Right. Thank you. At this time, we will take up oral argument in the case of Edwards versus Thomas. Special Justice Mark Welcome will be joining us today, sitting for Chief Justice Kemp in this case. And Justice Hudson will be participating in the case, but she is not able to join us on today's Zoom for the argument. So the court would recognize the attorney for the appellate.
Good morning. My name is Brian Brooks. I'm here on behalf of the plaintiff, or I guess we're the petitioner in this original action. As you know from the briefing, this case arises out of a tractor truck collision with a pickup truck. And by the way, I'm reserving 5 minutes for rebuttal. I see the clock on the screen. A collision between a semi and a tractor trailer truck. The driver of the semi, defendant Thomas, was operating the semi in the course and scope of his employment with McElroy Trucking, another defendant. Defendant Thomas admits that the collision itself was due to his negligence, and McElroy admits vicarious liability for that negligence. The reason we're here, as you know, is because both defendants wish to allocate a portion of the fault for the death of the plaintiff's daughter, Arlie, who was riding in the pickup truck, to her father, who was driving the pickup truck, for his failure to see to it that she was in a car safety seat, an infant safety seat. And so what brings us here is Arkansas Code Annotated 2734-106A, which precludes the ability to allocate the fault due to him due to the use of the car seat. So that's what we're here about and what the case is roughly concerning. I want to be very clear about one point arising from the statute. There are three big points that I think I need to make, and this is the first one. The evidence of the fact of the non-use of the car safety seat is not excluded by this statute. It will not be excluded from this case. The effect of the statute is to preclude a jury instruction allowing the jury to allocate fault to Mr. Edwards for failing to place Arlie in the car seat. That is apparent from the wording of the statute, because it reads that the failure to provide the safety seat will not be considered under any circumstances as evidence of comparative or contributory negligence.
Mr. Brooks, interrupt you on this, but when the statute talks about fault, doesn't the model jury instruction mean that fault and negligence are synonymous terms?
Yes.
And so how is it if they are putting in evidence of this as to fault? I mean, are we playing semantics here? Because fault and negligence are the same thing, aren't they?
I think that's the point I'm trying to make, that what the statute does is it precludes an eventual jury instruction that says you may allocate fault to Mr. Edwards due to the negligence of the asserted negligence in failing to put the child in the safety seat. Our position is the effect of the statute is a legislative declaration that doing so is not negligence.
So let me ask this question. You know, if we have a hypothetically slightly different situation and we have, say, a daycare that's transporting a 2-year-old child from one location to another through no fault of the daycare driver, he's hit by a truck that runs a stoplight. Would the estate of the child who was not properly buckled in be able to sue the daycare driver under this statute?
For a failure to have the child in a safety seat? Make sure I understand your question.
Yes, if that is the argument, is that the child was not in a safety seat and therefore suffered more injuries, would the child's estate be precluded from suing that daycare driver for not properly complying with the statute and buckling the child in?
I hadn't thought about it in those terms, but I think not. I think that's exactly the effect of the statute, that there's no cause of action arising from the failure to place the child in the safety seat. I think that's exactly what the statute says.
Across the board?
I think that's certainly the way I read the statute, yes. But the fact, in this case, the fact of non-use is going to be admitted to the jury. It's going to be presented to the jury. There's no way to try this case without doing so, because the child was ejected from the vehicle due to not being in the car seat. And there's no way to tell this story without having that particular fact told to the jury. So I think in your hypothetical, and in this case, both, there's no cause of action arising from simply the failure to have the child in the car safety seat. I think that's the way the statute reads, and to be consistent, we would have to say so. Yes, ma'am.
Mr. Brooks, I've lost your audio.
Is it back now?
I can hear you.
I still have you.
Justice Wood, can you hear me now? Justice Wood, can you hear me? Okay.
Yeah.
I don't know what happened.
Mr. Brooks, how is this case different from Mendoza? This court's precedent in Mendoza.
Well, it's different than Mendoza in a couple of different ways. And Mendoza was the third thing I wanted to bring up, so I'll go straight there. The first way it is different from Mendoza is the wording of the two statutes. They're completely different. The Mendoza statute said the failure of an occupant to wear a properly adjusted and fastened seatbelt shall not be admissible to evidence in a civil action, period. It's not admissible at all. As you will recall that I made this argument that that the Mendoza statute simply meant it was not negligence not to wear a seatbelt. And one of the things that you told me in the Mendoza opinion was, and I think this is very clear from the opinion, and I tried to make a big deal of it in the brief, is that the reason I was wrong is because of the way this statute is worded. The opinion goes to great lengths to straighten me out on that, in fact, that this particular statute, by using the words that I just talked about and that Justice Wonkum brought to my attention as evidence of comparative or contributory negligence and not admissible with regard to negligence, is not in the seatbelt statute that was at issue in Mendoza. And in fact, while at one point in time, the seatbelt statute had been worded in that manner, it was amended in 1995 to remove all of that analogous language. It's not analogous language, it's identical language. So the two statutes are completely different on the wording, and they're completely different in the way this court interpreted them in Mendoza. Now, I want to be real clear. Mr. Jones is correct in his brief when he says that is not a literal holding in Mendoza. I'm not saying Mendoza decided this issue. I'm saying that I made the argument in Mendoza and relied on Potts, and you told me that I was wrong because of the way this statute is worded, which I take very seriously. And because of that very wording existing in this statute, the interpretive effect of it is the argument that we were making in Mendoza ought to hold true in this case because of the way this particular statute is worded. That was a little bit convoluted way of getting to where I wanted to get with Mendoza, but I think I made the point.
Mr. Brooks, let me ask this. When we look back at the court's ruling in Johnson, they dealt with a provision of the Civil Justice Reform Act that talked about the collateral source rule essentially and said evidence of certain types of damages shall not include, shall only include the damages that are actually paid. I mean, isn't that the same argument that was put forth by the appellants in that case, or appellees in that case, that was a substantive limit, that was a substantive law?
I was involved in that case from an amicus standpoint. I don't recall precisely what the argument was, but it was at least a close cousin to the argument. I think the difference is there are several differences. One is, as you mentioned, the medical cost provision of Act 649 that was at issue in Johnson is a partial abrogation of the collateral source rule. The collateral source rule is in and of itself a hybrid common law rule of evidence and rule of the law, substantive law of damages. So it, on its face, is a rule of evidence, and to abrogate a rule of evidence is outside the legislature's prerogative under Amendment 80, Section 3. So I think you have to place the statute in Johnson within the context of it being a consideration of an abrogation of a common law rule of evidence in the collateral source rule.
But in Johnson, this court did not, they actually set forth what's a Brightline Rule, saying we don't look to the issue of whether there's a conflict between rules of procedure from the court. We look at purely, is this procedural or not? Is that not the standard that we're applying here?
It is the standard. I agree with that it is a bright line rule. All I'm saying is that the argument in Johnson that this changed substantive law as well has to be taken in the context of the fact that the statute in Johnson abrogated a rule of evidence. So even though a conflict between the rules of evidence, the literal rules of evidence in the court rules book, and the statute does not have to exist. One did exist there when you look at the statute in Johnson in terms of it being a common law rule of evidence. It's the collateral source rule. And interestingly enough, as I understand the collateral source rule, what the statute at issue in Johnson made solely the evidence available to prove medical cost damages would have been excluded under the collateral source rule. So it not only abrogated part of the collateral source rule, but it made evidence that was excluded under the collateral source rule the solely admissible evidence under the statute. We don't have those kinds of conflicts. We don't have those kinds of issues with this particular statute. And I think Johnson has to be looked at in that context as well. But the statute here, I think also the statute here has to be considered in the context of what its effect will be. And that's where we started with my point number one, which was that the effect of the statute is they don't get an instruction on allocation of fault, or in order to allocate a portion of fault to Mr. Edwards for causing this wreck. So those, and by covering all of those things, I essentially covered the 3 points that I wanted to cover, because the second one was a comparison of the language in the Child Passenger Protection Act with the statute at issue in Johnson. So I have covered those issues that I wanted to bring to your attention.
Counsel, can you talked about Mendoza a little bit in recognizing, this is you responded to Justice Baker about what, you said what you said in Mendoza, but clearly Justice Baker and myself dissented from Mendoza. So it really wasn't what we said. I think maybe Justice Wynn may be the only member of the majority in Mendoza. So what if, the court got Mendoza wrong and maybe even got part of Johnson wrong? And then specifically, can you address the fact that in Mendoza, my dissent talked about this court has given the legislature authority to make rules, and we still have not amended this rules of civil procedure or the rules of evidence to take away the powers that we've given the legislature to construct statutes in this area. And until we do so, how do we, in effect, overrule them?
That's a lot, and I will do my best. I reread your dissents in Mendoza this morning, and I couldn't help but think as I read them that, yeah, those arguments made sense when I made them, and they make sense in these dissents. I read Mendoza as foreclosing the 402 argument that you dissented on. That's why it's not raised again in this brief. Plus, I don't think it's needed in this particular case because of the way this statute is worded. No one has asked to overturn the Brightline Rule that this court has set forth. Before the court does that, I would hope that the parties and amici would be given the opportunity to brief that particular issue. But I don't think you have to overturn anything to rule in my favor in this case. You certainly don't need to overturn anything to rule in favor of Mr. Jones in this case. The 402 argument, I think, was correct when it was made, and I know this is totally outside the record, but I know there are recommendations to amend the rules of evidence to remove those references to statutes that haven't been enacted yet. But at this point in time, Mendoza is the law of the state, and no one has asked for it to be overturned, nor has anybody asked for Johnson to be overturned. And I think also the Brightline Rule established in Johnson is correct on its ground basis, and that is that under Article 2, Section 4 and Amendment 80, Section 3, it is this court's job to make rules of evidence, just like it's the legislature's job to make rules for how the House and the Senate operate. This court doesn't do that for them, and the Constitution has drawn that bright line. My time is up. Have I come close enough to answer your question that I can save the rest of my time for rebuttal?
I think so, but it feels a little bit as if it's whether something's substantive or procedural depends on sort of what suits you in the particular case, because it's really hard to distinguish it. So sort of what suits today's case is different than what suits yesterday's case. And I'm having trouble drawing the line, I'll be frank with you.
I think the hardest line to draw is the one from the medical cost provision as compared to Child Passenger Protection Act. And the way I draw that, and I will confess to you, I've struggled with that. I think that was an excellent question by Justice Wonka. The way I address that is that the medical cost provision dealt directly with a common law rule of evidence and overturned it, completely overturned it. Whereas this statute does not deal with the common law rule of evidence at all and doesn't overturn anything. It simply makes a statement about what is negligence and what isn't.
Mr. Brooks, let me ask this question. So you concede that the jury in your trial will be aware of the child not being in a child safety seat, correct?
Yeah. Yes, that's correct.
And so how will you, like in a closing statement, what do you feel like you can say about that fact?
Well, I haven't thought that far, but I think what can definitely be said about that fact is that it is a fact in the case that she was ejected from the vehicle. She was not in a car seat. She was ejected from the vehicle. And she was killed. Now, whether she was killed because she was ejected or killed, would have been killed anyway, I think is a matter of proof in this case that is being developed. I don't concede that she would not have survived I don't concede that she would have survived had she been in the car seat. I think Mr. Jones's expert is going to say that, but there's a counter expert that says something totally different.
Well, my concern is what kind of weight that the jury will be able to give to that evidence. And we understand that that they will not be instructed that it could be used for comparative fault or negligence. But I'm just, I'm concerned about, okay, it's admitted the child was not in the safety seat. Ladies and gentlemen of the jury, that's a fact. But at some point, the weight of that, the jury has to at least have an understanding of what kind of consideration that they should give that. Am I correct on that?
I think so. And under Rule 105, the jury can be instructed that it is not to consider that as negligence on the part of Mr. Edwards. And we assume juries follow instructions.
Right. Okay.
And frankly, I think they do. I've observed enough trials. I don't try cases, but I go to trials. I've been in enough trials where the jury has done what it does, and it's very clear that they understand instructions and they follow them. And I think under 105, that's the instruction the jury can be given if there's any concern about how the jury is going to use this particular piece of evidence. It'll be told what it can't use it for.
Okay.
And we assume that it won't.
All right. Thank you.
Mr. Brooks, I want to understand your argument in response to Justice Wood with regard to the collateral source issue. Prior to Johnson, this court has held in Seipolt that back in 1990 that that they look at whether there's a conflict. And so are you arguing that Johnson's holding is better understood on the medical cost it being in conflict with a rule of evidence, and so that's why the court ruled the way it did, as opposed to how the court described how they ruled the way they did?
No, I am saying that the argument that Johnson simply changed the substantive law of damages alone cannot be divorced from the fact that the statute at issue in Johnson specifically changed a rule of evidence. That's all I'm saying. The substance procedure argument that was made in Johnson can't be divorced from the fact that there was a conflict with a common law rule of evidence that was created by that particular statute.
So that's answering his question. Yes. I mean,
no, not to me. No, that's not a yes, because the bright line is that the legislature cannot create rules of evidence. It created a rule of evidence through the statute in Johnson when you view it in the context of the fact that the collateral source rule is a rule of evidence, and the statute there abrogated part of the collateral source rule. Now, if the medical care cost provision was not part of the collateral source rule, then I think the argument would have carried the day that this particular provision may have been substantive. But because it's a rule of evidence in and of itself, then my answer is no. It did not decide it based on that basis alone. It was only you have to take Johnson's. You don't have to do anything. I can't tell you what you have to do. You tell me what I have to do. But in my mind, I can't divorce the fact that the statute in Johnson changed the rule of evidence from the substance procedure argument that was made in Johnson. Justice Womack, you look like you're about to ask me a question.
Yes, sir. Mr. Brooks, in light of the 402 discussion and the discussion we've had on the procedural aspect of statutory rules of evidence here, how would you contrast this with, say, the rape shield law? I mean, if we find that we're procedural here because the legislature has limited the use of this information for particular evidence, how is that different from what the legislature's done in the rape shield law that we've upheld repeatedly?
I have not dissected the rape shield law enough to give you an educated answer to that, to be very honest with you. I can't even remember standing here right now whether the rape shield law has been reviewed since the enactment, the passage of Amendment 80, Section 3.
Well, I will tell you, Mr. Brooks, that this court did, sorry, Sean. I will tell you that this court did adopt a rape shield law as part of our rules. I was aware of that, and I think that is one difference, that we now have a rape shield rule that Yes.
adopts the statute rather than the other way around. But it was my understanding that the cases dealing with the rape shield statute predated Amendment 80, Section 3.
Mr. Brooks, the court did address the rape shield statute following Amendment 80, and in that decision, I believe it was CB versus State, they talked about the distinction being that in the rape shield statute, it did not have an absolute bar on what the court could or could not admit as relevant evidence. When I look at this particular statute, does this statute not create an absolute bar that this court was hesitant to uphold in the cases dealing with the rape shield statute?
No, there is not an absolute bar. There's a bar to use of it as comparative or contributory negligence, or with regard to negligence. The evidence comes in. Evidence can come in for all sorts of different reasons. Just telling the story is part of it. The use of the evidence is all that is governed by this particular statute, not that it comes in or doesn't come in, because it doesn't prevent it from coming in the case for other uses. And that's what Rule 105 is all about. Evidence can be used for one thing and not for another.
Thank you, Mr. Brooks. We have 4 minutes and 10 seconds on the clock for your rebuttal. We've suspended the clock during that extended questioning section. So
yeah, I saw that you stopped my clock, and I appreciate that very much. I'll reserve the remaining time for rebuttal.
Thank you. And the court will recognize Mr. Jones for respondent.
May it please the court, I'm Greg Jones. I represent the respondents in this matter. I've got with me today Kristen Mortars and Todd Wooten. I almost feel like throwing aside my notes and focus on the questions that y'all have raised, because this has been, I won't say it's the hottest bench, but it's been pretty hot the last half, and I appreciate that. That's what oral argument should be about. I'll come back to the points that I had planned to raise. Let me try to address first some of the points that you have raised, because that, I think, is where the rubber meets the road. The theme that I think Justice Wood mentioned is basically, what sort of rule do we have? And with all due respect to Mr. Brooks, who, by the way, is a friend of mine, at least I hope he feels he is, I know I feel he is that he likes Johnson as a bright rule, except when he doesn't. Now, that's not a rule that we in the bar can contend with. So a bright rule is a helpful rule to the practice of law. It's a good rule as a matter of public policy. So that's sort of my first notion. I don't think you can have the position that petitioners have made and have it be consistent with Johnson's Brightline Rule. I want to mention one other point Mr. Brooks made. He said that this statute is not deviating from any common law notion. Well, just a minute. Think about it. We're talking about negligence. And if we trace the history of seatbelts before this court, we can go back long before this statute was passed. And we know, for example, the beginning of the use of the debate over seatbelt evidence and things like this goes back before this statute was passed. Certainly in the Baker v. Morrison case, the court recognized a common law rule as to use of seatbelts. Now, it didn't arise in the context of child seats, but I don't think there's any practical difference there. You can go back before Baker. You can go to Harlan v. Curbo or the Tucker case, and I forget the rest of the name of that citation. I hadn't read that in a long time. But this court system has recognized the interplay between use of seatbelts and negligence or comparative fault going way back before the statute began. So those are some preliminary thoughts I wanted to share with you. As to the point about the rape shield statute, Justice Baker, you're absolutely right. You passed Rule 411. I forget exactly the date, but that was in direct response to and in the wake of the Nelson v. State case, which I think, Justice Wankham, that may have been the case that you were thinking about.
That's correct.
That basically said, and I'll be honest with you, Nelson is kind of an oddity. Nelson basically said that, okay, the legislature has created this framework, but the important thing to the court in that particular case was that there was a safety valve. You remember the words in the Nelson case, which was the judge retained great discretion. And that's what Johnson's about. That's what Broussard's about. That's what Amendment 80 is about. And that's what this case is about. It's about the discretion of trial judges to do the quintessence of what trial judges do. They have to decide the propriety of evidence. And the problem here with Section 106A is that it deviates from that. That's where it totally wrests the issue away from the trial judge. That's one of the main reasons why it should be struck down as inconsistent with the separation of powers doctrine. Let me delve back to the prepared remarks I had for just a bit. What does the separation of powers doctrine really mean? Of course, we're talking Article 4, Section 2, the Constitution. I think for purposes of this case, there are four basic components that are germane. Number one, it's what I call the stay in your lane rule. If you got a branch, you got to stay within the parameters of that branch's authority. You do not trespass into another branch's domain. Number two.
Let me ask because I think that gets to the issue that Justice Wood raised a moment ago on the Rule 402. And is, if the court were to accept that 402 delegate its exclusive authority to the General Assembly, are we not refusing to stay in our lane, as you put it?
Well, it's akin to that. It's actually the flip side of that. You remember the Hobbs v. Jones case, lethal injection case. What did this court say in that? And I apologize. Your question prompted an issue that we didn't brief in this sense, and it wasn't directly here. But in Hobbs, it said basically the legislature could not delegate to the Department of Corrections how and where and when lethal injections would occur. They can't do that. The danger, I think that Justice Wankham that you're referring to, is how far can you go through a Rule 402 to delegate back to another branch of government the authority to do something? I mean, what if 402 said, well, we're going to defer to the legislature and the executive branch to do what they please with respect to reliability or to relevance? My personal notion is I don't think that can be done. I think there's certain restrictions that are imposed. Now, what came up in the Bedell case, and Justice Wood, I think this was part of the issue that you had in the Mendoza case. What came up there was the notion that certain things are different. And so for purposes of Rule 402, matters of privilege, which was how it was construed in Bedell, those are a safety valve whereby the legislature does have some prerogative to determine, because that's not that's not an evidentiary question. It's a question of privilege. So I hope I've addressed your point. I want to say this also about the third and fourth components of separation of powers. Number one, a law can simultaneously be partly substantive and partly procedural, right? It can be. And that is exactly, I forget now who asked this question early on, but that was what was going on in Johnson, because there were components of that decision that had substantive aspects. In fact, I think this court said, I believe it was page 8, that it was clearly modifying joint and several liability. Remember that? And yet what happened? Johnson said, too bad. There are other facets of that statute that bring it down. So the point being that to the extent that this could be possibly construed within the separation of powers notion as having a substantive component, what you have to keep focused in on, and I'll get to in just a moment, is how does it have an evidentiary component? Because if it does, that strays beyond the powers that the legislature had. The fourth component that I want to remind the court of is that a legislature this legislature can't create rules of evidence and procedure, even if the rule doesn't directly conflict with existing court procedure. Now, Justice Wankham, you mentioned the Seipold case. And you remember in that continuum of decisions that have come down over the last 40, 50 years, where Seipold fell. Seipold suggested where this court was headed. Because before Seipold, you had the Jackson v. Osment case that said, the legislature has the right to make evidentiary rulings, and the judiciary has the right. So, well, let's, why don't we all just get along? That's how I would construe that decision. But Seipold then came along and said, oh, wait a minute, we're not going to do that. We're not sure what we're going to do, but we're not going to do that. And then Wiedrich came along in 1992, I believe. Does that sound about right? And Wiedrich said, this business that we talked about in Jackson, we got it wrong. We are preeminent when it comes to things that are in our lane.
Mr.
Legislature,
Johnson,
you must stand out.
let me interrupt you here. When the court addressed it in Wiedrich, wasn't that the statute with the filing of a certain, wasn't that dealing with the filing of a specific thing that was in conflict with Rule 3 on commencement?
And I couldn't hear the first part of your question, Your Honor.
Sure. So in that Wiedrich case that you cited, wasn't that case involving a situation where the statute required something particular to be filed with the complaint? And so this court talked about it in terms of being in conflict with Rule 3, the commencement?
I'll be honest with you, I don't remember all the facts from that particular decision. That hasn't been directly germane to our case. So I'll have to defer to your memory on that.
Here's this, you talked about it in terms of a Brightline Rule. And so if we talk about the Brightline Rule from Johnson, and we apply it to all sorts of other statutes that have procedural components and substantive components intertwined. For example, the John Doe statute, that one has very specific procedural requirements that have to be complied with by a plaintiff in order to trigger the substantive benefit of a tolling of the statute of limitations. So how are we to address those sort of situations if we run into the application of the Brightline Rule that you talk about applying in this case for the seatbelt statute?
Well, I think that we have to be consistent. And I think in that instance, I haven't thought, as Mr. Brooks said, he hadn't thought about that. I hadn't thought about the John Doe statute, but there are perilous problems that come up where the legislature is creating rules of procedure for the judiciary to follow. So it could be that some of those statutes may bear analysis as we go forward.
Mr. Jones?
Yes.
I see you looking around to see who's
I'm
asking.
so sorry. It's yes.
It's a little bit hard in Zoom days, but my question and I think the difficulty that we have sometimes is we're trying to everybody stay in their lanes. But it feels as if a lot of these decisions are policy-based decisions, and that is more suited for the legislative branch. And so decisions about what should be considered negligence and those types of liability decisions that are really suited for the legislative body, not the judicial body. And so how do we do that with this Brightline test when it does feel like it's encroaching onto, the rules of procedure, but really what they're doing is trying to set policy for the state?
Well, and that's a good question. And that goes to the essence of the challenge that we have. But look at the statute that we have in question here. There is a test that was articulated in Johnson. And basically it says, does the legislation limit evidence that may be introduced? Remember that? Does it limit the evidence that may be introduced? And does it dictate what evidence is admissible? That's the test. And I think that addresses the problem that you've raised. Now, it's important, and I'm going to come back to this in a minute, but if we look at section 106A, it could have said, the legislature could have said and addressed the issue that you have just raised. The legislature could have said failure to provide a child passenger safety seat is not negligence. Now, I might disagree with it on a matter of policy. And I think probably if you think about the responsibility, say, of a parent, has, notwithstanding this statute, has a responsibility to take care of their children. And that would include strapping them in if you had that available. But the point is, what the statute that we're wrestling with today doesn't address the specific question that you raised, Justice Wood. The point I think you made was, shouldn't the legislature be able to declare what is negligence? And probably the answer to that is yes. But that's not what the statute said. That's not what the legislature did. It said failure to provide or use a child seat, and then the magic words, shall not be considered under any circumstances as evidence of comparative or contributory negligence. That language that, and I think we highlighted in our brief, that is what takes this from the problem that we've got now and compares it to what you've described. The legislature could have said, Justice Wood, what you were getting at, but it didn't. It went beyond that, and it intruded in the province of the trial judges to determine what shall be or what shall not be considered as evidence. The second clause of
when we talk about the policy determination set forward, if it were to be the policy that that's not negligence, that raises a question in my mind on, is the evidentiary component of that statute severable? Can this particular statute be severed? Can that procedural aspect of it be severed off, like we did in Broussard, where we severed the language, by expert testimony, so on, in the Medical Malpractice Act? I know in that statute, it said it was a severable statute. Do we have comparable language like that or analysis for this statute?
I think that gets you in for purposes of this statute. I think that gets you into judicial legislating, and I don't think you can do that. I think it's important to note that the clause I was referring to is only the first clause in section 106A. It's probably and I think you're getting to that, Justice Wenker, it's probably the lesser of the two evils. It's still evil, but it's probably the lesser of the two. The second clause is the kicker, and it says, nor shall failure be admissible as evidence in the trial of any civil action with regard to negligence. I don't know how you get around that. The way that the petitioner has gotten away around that in the context of this statute is to say, hey, we're going to leave out some of these words. We're going to leave out, just a few words like shall not be considered as evidence under any circumstances as evidence. And we're going to leave out the part about it shall not be admissible as evidence. Remember what happened in the seatbelt statute, 703. What did the legislature do? What did they communicate that is germane to this issue right here? If you look at the final clause, when they deviated from the language that were shared by the seatbelt and the child seat statute, if you look at 703B1 and B2, what the legislature did was start to talk about admissibility. And they said a trial judge shall hold a hearing as to admissibility of such evidence. Now they're talking about the products liability exception in the seatbelt statute, okay? But also in that very same section, they again talked about admissibility. The point I'm making is that when this scheme was set up, the legislature knew exactly what it was doing. It knew exactly what it was referring to when it said shall not be considered under any circumstances as evidence. They were divesting the trial judges of the inherent authority to decide what may be considered under any circumstances as evidence.
Mr. Jones,
yes.
Isn't it possible that that language was actually intended as creating the elements of the cause of action or the defense of the cause of action rather than purely an evidentiary dictate?
Is it possible? I suppose it's theoretically possible, but
can it be read that way? Can it be read that the legislature was creating the elements of that defense?
I don't think so. I think we have to presume that the legislature would do a much better job than that. And that goes back to the point I raised about how they could have achieved the ends. To say, basically the way that Mr. Brooks has phrased it, that it's translated as saying, this is not negligence. The legislature could have done that. It didn't.
Mr. Jones?
Yes.
Yes. While you have worked on this case, and this court has had, repeated cases in this area about substantive procedural and the legislative role versus the judicial role, have you had an occasion to think of a way that the test could be better or could be improved?
Yes, Your Honor, I think so. And I think it really goes, the old dichotomy that we have used for a long time between substantive and procedural, it kind of goes back to the issue that was raised by Justice Felix Frankfurter in the decision the guaranteed trust case, not to mentioned there. And if any of y'all ever had Professor Leffler for conflicts, you don't have to confess right now, but if you had him, you remember what was said about tests along these lines and the substantive versus procedural dichotomy. And one of the things that he would say is that in this process, it is tempting to think that substance and procedure as defined in one context of the law can be used in any context of the law. And you recall, again, if you endured his course, if you survived it, apparently you did if you were there, you know that what he said is that is a siren that pulls you upon the rocks. It needs, that temptation needs to be avoided. I think the words that he would use, avoided like original sin. What he was saying is it was easy with this substantive versus procedural to get into all kinds of manifestations. Back to your point, Justice Wood, I think you can do better than that dichotomy between substance and procedure. And I think you can go back to the language that was articulated in Johnson, where it says, does the legislation limit evidence that may be introduced? That's a much better, clearer rule for us practicing in the hinterlands to apply. Does it dictate what evidence is admissible? And if that's the case, then it intrudes on the province of the trial courts. I think that may cure a lot of the problems that we've had in trying to deal with these issues as manifest in the sequence of decisions we're here for.
Mr. Jones, I'm sure Mr. Brooks' argument here is that it doesn't. What it does is say, as a matter of substantive law, failing to use a child seat is not negligent. And therefore, it doesn't say it can't be introduced. It just says it doesn't prove negligence. And it's within the legislature's purview to define what is negligent.
Well, obviously, unless it's, obviously, if it weren't relevant, it's not admissible under 402. So
it's not admissible for the purpose of establishing negligence.
No, that's what I'm saying. That's right.
Because it's not negligent by definition. Why is he wrong about that?
He's wrong about it because it goes beyond that. And it basically, and number one, it's not defined that way in the statute. That is not what the legislature said. In theory, it could be what the legislature might say in the wake of a decision, but that's not what was said. He's articulating a standard that does not comport with what you read. And you remember in the Department of Human Services versus Howard case, what this court has said then and said repeatedly. We must give meaning to every word in the statute. We can't pick and choose. We have to give meaning to every word. If you are true to that concept, then the position that Mr. Brooks has articulated does not pass muster. I'm afraid my time is up. We would ask that the court answer the question posed from Judge Hickey in the affirmative, that this statute be declared unconstitutional as a violation of the separation of powers doctrine under the Arkansas Constitution. Thank you very much.
Thank you. Mr. Brooks, you have 4 minutes and 10 seconds for rebuttal.
I'll try to be rapid. I'll start with Baker against Morrison. Baker against Morrison is not a common law rule of evidence. Baker against Morrison simply ruled that under the common law, it could be negligence not to use a seatbelt. It's kind of my point. It's a substantive common law rule, not a rule of evidence like the collateral source rule. So Baker against Morrison, I don't think gets us much of anywhere. Justice Wonkum, as much as I wish I could tell you you could simply rewrite the statute, I don't think you can. I don't think you can strike words from the statute, but I don't think you need to because of what Justice Baker just said. That is, this statute does not exclude evidence. This statute determines what the evidence can be used for, as is the case with all sorts of statutes that determine the substantive law. If what Mr. Jones, who is my friend, by the way, just said that if a statute controls how evidence can be used or something like that, if that is true, then the locality rule found in the medical malpractice statute is a violation of Amendment 80, Section 3, because it controls the sole evidence that is admissible with respect to the standard of care. It is the local standard of care. All other testimony about what a standard of care is completely irrelevant and ought to be excluded from the case. So I don't think that part of the Brightline test that Mr. Jones and I have been back and forth about really gets you there, because statutes.
This on the statute's language itself, but look to the second clause, Section 106A. It uses language that sounds an awful lot like a determination of admissibility or not admissibility, where it says, nor shall failure be admissible as evidence. And isn't that a statement of a rule of evidence?
It would be if it stopped there, but it doesn't stop there. In any civil action with regard to negligence, if the with regard to negligence were not in here, then yes, you would be absolutely correct. Under the Brightline rule that is enacted, that is established in Johnson, which I think is about the best you can do for staying in your lane, for the those two branches of government staying in their lane, that had the statute stop there, this would be unconstitutional. But it doesn't. It doesn't stop there. It says with respect to negligence, just like the medical, not just like, but similar to the medical malpractice statute, declaring that essentially the only relevant standard of care testimony is local standard of care testimony. So I think just the notion that a statute's going to dictate how evidence is going to be used is not an Amendment 80 Section 3 problem for all the reasons that we've talked about in our brief and before.
But when we go to Broussard, and help me understand this and understand your position on this, in Broussard, the portion of the statute that was held to be an evidentiary provision that was unconstitutional was the first clause where it says, by means of expert testimony provided only by a medical care provider of the same specialty. In this court, that was an evidentiary standard. I mean, that is saying this is the evidence and this is how you prove, so to speak, that locality rule issue that you talked about just a moment ago. So help me understand how, in this case, this statute is different from the language that we held unconstitutional in Broussard. I don't think I've got a clear understanding of your position on that.
Sure. The language in Broussard talks about who is qualified to give testimony. That is a Rule 702 problem. That is a qualification of witnesses issued that is directly an evidentiary point. It's who can be qualified to deliver the required testimony as to the standard of care. Whereas in this case, all the statute says is this evidence cannot be used to prove comparative negligence or negligence. That's all it says. It's not saying who can deliver it. It's not saying the evidence is excluded. It is saying that the evidence is not proof of negligence or comparative negligence. So it is in my mind more akin to the declaration in the medical malpractice statute that the only relevant standard of care is the local standard of care. That's the dichotomy that the two statutes have in my mind.
Thank you, Mr.
My time is expired. We would ask that the statute be upheld.
Are there any other questions? All right. Thank you, Mr. Brooks, for your argument. The court will be adjourned. I'm going to say until 11:30 when we will start with the conference of this case. Thank you for your arguments, counsel, and we'll be adjourned.
Thank you.